Morning and welcome back to my channel. This is Michelle with Live Life Whimsically. And I thought today I really kind of wanted to discuss what's happening on the Real Housewives of Beverly Hills with all of the Erica Jane drama, the stuff with Kathy Hilton a little bit, only because it sort of goes with what's happening with Erica. But in particular, the crappy way that Sutton Strock talks about and to Erica Jane or Erica Girardi. So anyway, yeah, if you wouldn't mind liking the channel, subscribing to the channel, hitting the like button, maybe sharing this video with your friends, that'd be awesome. I'm a baby channel. I don't know what the heck I'm doing yet. I'm still trying to get my feet wet. I talk about all kinds of things on this channel. It's whatever whim is in my mind, thus live life whimsically. So if you would like me to look at something and give you my old Greek lady opinion on it, I'd be happy to do that. I just want to check and make sure that I am live on Facebook as well. And then we'll get started with the court documents that I found from last month. Anyway, yeah, it's out there. That's good. So I wanted to get the court documents because I didn't really want to just read what some journalist or blogger had to say. I really like Erica. I think Erica is one of the realest people out on any reality or Real Housewives franchise. I really do. Teddy Mellencamp was pretty real too. I think after a while, when you have money, you sort of forget where you came from. I don't feel like that with Erica. I think Erica knew she was balancing on shit and it could be all taken away from her within a minute. That does not mean that I think that Erica knew what Tom was doing. I don't think that at all. I think Erica just knew the precarious place she was in, and I think she kept her mouth shut for a long time. And I think that the people that talk to her now and talk about her now really don't even take into consideration the amount of adjustment it must be taking for her to change the way that she lives. And listen, I mean, I know that a lot of people will probably listen to this and think, oh, poor pitiful her living in that 30,000 square foot house and having all that money in private jets, and now she doesn't have anything. It still looks like she's doing pretty good to me. And it does. I'm not going to lie about that. I had a minimal amount of money once where I was in a really comfortable position. I could do pretty much anything I wanted to do. I mean, I couldn't buy, $150,000 handbags like she could have, but I still lived really comfortably. And my husband got very sick and our business imploded, and we had to move from 4,000 square feet to 2,200 square feet with 5 cats, 4 adults. And it was hard. It was really, really hard to get used to not spending money the way that I did before. It was hard to not donate money like I did before. So I sort of feel for her and what she's going through. And I think that people, it's easy to sit around and make fun of, or to say that this person deserves what she's getting or whatever the heck it is. But really, until you walk a mile in somebody else's shoes, you shouldn't be so cotton picking judgmental about what they're going through. You don't know. And divorce is hard no matter what, regardless of how much money or money you don't have. Divorce is hard. Even if you want out of the marriage, divorce is hard. And so I think we should give her a little bit of grace and the year to go crazy, maybe 2, because this divorce is not going to be over in 5 minutes. It took me 2 years, and all I thought about was my kid and child support. I didn't ask for anything else. So I can't even imagine when you have all these businesses and things entangled with it and people that didn't get paid, those poor victims. I feel, and don't let anything that I say be misconstrued as I don't care about those people, because I do. What I don't like is watching Sutton Strock act like Erica's legal problems are somehow her legal problems. That seems a little selfish and narcissistic to me. If you have friends that are going to judge you based on something you have that your friend does, then those aren't your friends. And I get it. I guess in Beverly Hills, and when you have that much money, you got to worry about what other people think about who you hang around with, so you don't get left out of the cool people circle. But then you're really not that person's friend. And honestly, if you're going to do a reality TV show and you're ate up over what people are going to think by what other people do, you probably shouldn't be on that reality TV show to begin with. And finally, there's nothing real about these housewives at the fuck all. No, I mean, I never had nannies. I don't know about any of you that are sitting out here. And I never had, housekeepers and stylists that followed me everywhere. I'm my fucking stylist. I'm my housekeeper. And I am the nanny and chief cook bottle washer. And I am the lover of the man in my bed. So, it's a whole different world, you know? So anyway, I started looking and I ran across the court documents that were filed. Let me look at this. In the Superior Court of the state of California. And this was, where's the stampy? That says, I don't even see the stamp. I found these, it was in August sometime. So anyway, here's what it says. A memorandum of points and authorities introduction. Erica Girardi is the single largest beneficiary of the single largest fraud by a law firm in the history of California. With her help, Ms. Girardi's husband, Tom Girardi, and his son-in-law, defended David Lira, stole more than $100 million from clients and attorneys like plaintiff Philip Sheldon and Robert Finn, who referred the clients, and Ms. Girardi spent much of that money financing her lavish lifestyle and her expensive and unprofitable dream to become a pop star, as chronicled on The Real Housewives of Beverly Hills. See, guys, this is the other thing, too. You put your whole life on display and then you hit some legal snafu, they're going to go get everything. I don't know how many of these women got to go down before other women get the idea that they're going to catch you, like Teresa Giudice, and who else? That lady in, I don't even watch the one out in Utah too often, but in the beginning, that lady got in trouble and they were going to arrest her ass right off the bus. I mean, you got to be careful with the shit you pull. And I guess must be a thing with rich people that they think they're untouchable. But honestly, those ladies are rich, but they're not rich like the people that control the fucking world. You know what I mean? So you ain't getting away with a whole lot of shit like you see other really rich people get away with. Those are the people that control everything. That's not you. That's not you at all. You might think you're cool and doing homeless, not toothless, or whatever the fuck that thing was that Dorit did, but you're not them. Nope, not at all. Ms. Girardi admits that she signed all the tax returns for the company EJ Global LLC, which received at least $25 million from Girardi Keese and facilitated a massive tax fraud by her husband, and Girardi Keese. The career she had was the conduit for the tax fraud. She admits she signed subordination agreements for lenders to keep money flowing to her when she already knew the Franchise Tax Board was auditing her company, which operated at a loss for over a decade, but continually spent law firm money on what the FTB alleged was a music hobby and not a career that ever generated any meaningful income. Meanwhile, Ms. Girardi consistently made public statements and continues to make inconsistent and nonsensical public statements designed to keep creditors at bay and obfuscate the truth. The thing is with signing the tax documents, my first husband was self-employed and we didn't have an accountant. He did the taxes. I was a stay-at-home wife and I signed all of those. I didn't know what he was doing or what he was writing down or what things he was saying were income or not income or wrote off. I had no idea. And in fact, he died not too long after we were divorced, and the IRS was coming at him. And my accountant that I had after the fact, because I married again, and that's the husband that had all the money. That accountant saved me from the IRS because they were coming for me because I signed those papers. So there's ways around that. If you have a good accountant and a good attorney, that you don't have to be in trouble for that stuff. I'm sure lots of lawsuits, in my opinion, and I'm not an attorney, I'm a fucking real estate agent, but lots of lawsuits, they throw shit out at everybody that they can possibly figure out might be a party in the suit, just so they can see if they can get something from somebody. And I'm sure that all the flashy shit that Erica shows on the Real Housewives isn't helping her any, and they want those goddamn earrings back and probably some other stuff, and so that's why she's a party to this. But when she says I signed whatever he told me to sign, I believe that. She was a fucking exotic dancer, you guys. She wasn't like the brains behind this operation. Clearly, Tom was the brains behind the operation. And if you get plucked out of obscurity in a topless bar someplace, or a bikini bar, whatever it was that she worked at back 20 years ago, you're signing whatever they tell you to sign. You're doing whatever they tell you to sign. Plus, we don't also know what kind of trauma she had before she met Tom, and even after, while she was in there. I'm pretty sure he ran a tight ship, and she had to do whatever he said. So, Grace. And we don't know anything that went on inside of that house. We have no clue. Ms. Girardi received all the benefits of the misappropriation of funds and the tax fraud, but now conveniently claims she didn't know anything. She just signed whatever she was asked to sign under penalty of perjury, gave whatever sworn testimony she was asked to give, and didn't ask questions of anyone, despite access to numerous attorneys and accountants who could have advised her on the potential legal issues in which she is now embroiled. But if you're married to an attorney and your marriage is halfway decent, or if it's not decent, but he's the boss and you need to shut your mouth so that you keep your lifestyle, you are signing whatever he puts in front of you. Sorry, that's the truth. Plaintiffs are entitled to have a jury consider the amount of evidence establishing Ms. Girardi's actual knowledge, which includes inferred knowledge of feigned ignorance, and Ms. Girardi's self-serving denials are sufficient as a matter of law to obtain summary judgment. Okay, so they want her to come into court and they want to question her under oath and in front of a judge or a jury. And okay, I'm all right with that. But I understand also why she's not trying to do that. Who wants to do that? Because any money that she does have is going to be ate up in all of this bullshit. And she ain't getting nothing from Tom. So there's that. If the test was simply ignorance or acting like an ostrich, no plaintiff could ever survive summary judgment. This is not the law. Knowledge is almost always inferred with circumstantial evidence. CAC 1 1910, actual knowledge can and often is shown by inference from circumstantial evidence. It must be case law in California. In this case, there is a ton of it as well as willful blindness, which under California law is to be regarded as equivalent to actual knowledge. And by the way, I'll leave a link to this in the description box, so just look for that later. Both allow the plaintiff to survive summary judgment so that the jury can make the call as to credibility and believability of the defendant. Ms. Girardi also cannot avoid liability with her self-serving refrain that she didn't read anything she signed, including her own tax returns, subordination agreements, bank applications, the operating agreement for her LLC, and so on. She probably didn't. I didn't read that stuff. And my tax documents were only, 10 pages long. Can you imagine what theirs must have been? Shit, she ain't reading that, especially if your husband is an attorney. You're believing what he's telling you. Just sign this, baby, because we got to file the taxes, okay? Yep, all right, I'm signing them. Thanks, babe. And then out the door she went. She ain't reading that shit. She's not getting her own attorney. And then who's paying for that attorney? Tom? Because what are you going to do? Get his attorney, get his accountant to tell you that what he's doing isn't fraudulent? Nah, sorry, I don't believe that. Let's see, where was I? Ms. Girardi signed tax documents for EJ Global that represented the $25 million receivable due for the funds Girardi Keese expended for EJ Global was a legitimate receivable of the firm when it was obviously fraudulent and would never be paid back. She cannot claim, after receiving all of the benefits she obtained from the false representations she attested to by signing all of these documents that she didn't know what she was signing. She signed whatever she was told to sign, and that the content and meaning of the documents are completely foreign to her. Totally believe that. Totally believe she didn't know what she was doing. It is well established in the absence of fraud, overreaching, or excusable neglect that one who signs an instrument may not avoid the impact of its items, of its terms, on the ground that he failed to read the instruments before signing. And then they cite case law again. And the case law says if this were permitted, contracts would not be worth the paper on which they are written. But I don't know how it is in California, but I'm telling you, in Florida, the IRS was coming for my ass, and I got out of it because I could prove that all I was a housewife, had nothing to do with the filing of those taxes. And then why aren't they suing the accountants? I would be suing those accountants too, because then they had to put their name on the document as a preparer for it. So I don't understand. But anyway, Ms. Girardi is asking the court to endorse a defense that, if allowed, would result in complete chaos. Ms. Girardi is proposing an insane policy that allows one spouse on a joint return to steal money and give it to the other spouse because the other can receive judicial immunity by simply saying they didn't read what they were signing. Ms. Girardi signed all of the documents which facilitated the theft. She was part and parcel to the whole thing, and she is not shielded by some made-up immunity that doesn't exist under the law. But she didn't understand what she was signing. And I don't think that, I mean, why would you question your attorney husband? I mean, I get that there's no law to stand up for this, but I don't know. I'm going to just guess that there's a bunch of bitches in Beverly Hills that sign whatever their fucking husbands tell them to sign. And sometimes I think that the husbands are doing that shit on purpose to try to get the broad in trouble and mitigate their own damages to what the heck's happening. I don't think Tom Girardi is not so stealthy that he wouldn't have tried to throw some shit at her. Maybe if he saw it coming before he started losing his shit, if he really lost his shit, like who knows? Who knows if he's really got Alzheimer's or dementia? I mean, she says that he does, but who knows? You know what I mean? And then if he did, how long did he have it for? What, should he have been practicing law and written all that stuff up for her to sign to begin with? I mean, there's so much to unpack. Separately, Ms. Girardi cannot escape liability by simply pointing the finger at Tom Girardi and claiming that Mr. Girardi and Girardi Keys were responsible for handling her own LLC's finances. Yeah, she kind of can. That they were her attorneys. Erica Girardi and Tom Girardi inextricably intertwined their business affairs, making them fiduciaries and agents of the other. Excuse me, Tom did that. Tom did that. I don't think that Erica thought that at all. Ms. Girardi is a competent adult who is very capable of making her own decisions. Now, not while she was in that house. She cannot authorize Tom Girardi to act on her behalf with respect to the operation of her own LLC and other affairs, spend all the money she received as a result of Tom's handling of her affairs, and then complain that she didn't know what her agent was doing when he gave her $25 million of stolen funds. I think she says at some point in The Real Housewives that she didn't even know that there was that much money in the account. Like she didn't even look at the bank accounts. You know what I mean? So I don't know. I mean, I still don't look at my bank accounts with my second husband. So there's that. And that makes me kind of dumb, I know. But I don't have that kind of money, so no harm, no foul. That does not entitle her to summary judgment. That entitles the parties to a trial where a jury will hear Ms. Girardi's defense and determine if that argument absolves her based on the law provided in the jury instructions. This is what trials are for. They're just arguing to get this in front of a jury. Ms. Girardi claims she's entitled to summary judgment because, one, the written contingent fee agreements prepared by her husband's firm and entered into by plaintiffs Girardi Keys and their joint clients were purportedly illegal and unethical. Well, okay. Let's see anybody. Okay, I want to see if I can share the screen with you guys. Let's see. then maybe you could read it with me. Let me see how that works. I'm not used to this yet. I have not. It's just showing you the EV mux. So that didn't work. I have to still learn this. I don't know how. Let me see if I go to this and then I go over here. Nope. I wonder. I don't know how to do that. Oh well. Let's go back. Like I said, I'm going to share this anyway. Okay, so two, regardless. Okay, wait a minute. Let me just go back first. Ms. Girardi claims she is entitled to summary judgment because one, the written contingent fee agreements prepared by her husband's firm and entered into by plaintiffs Girardi and Keese and their joint clients were purportedly illegal and unethical. And two, regardless, she did not know plaintiffs personally, and she was spending their money. First, the claim against Ms. Girardi for aiding and abetting her husband's breach of fiduciary duty is a tort claim that's separate from the contract claims against Tom Girardi and Girardi Keese that plaintiffs dismissed because of the bankruptcy. It's absurd that Ms. Girardi thinks she's absolved from stealing and spending tens of millions of dollars of other people's money because her husband prepared agreements for the victims to sign that purportedly violated CRPC 2-200. But the law is not so twisted. Plaintiffs are not seeking to enforce the purported defective retainer agreements, but even if they were, Ms. Girardi is wrong that the agreements preclude recovery by plaintiffs. Second, Ms. Girardi carefully and cleverly worded declaration filed in support of her motion utterly fails to satisfy her burden on the motion, which means the burden should not shift to plaintiffs and the motion can be denied on that basis alone. Every statement in her declaration is narrowly limited to her specific knowledge of plaintiffs and the TXI cases for which they were owed half the attorney's fees, about $5 million. See the Erica Girardi declaration 5. I have no knowledge of. I never communicated with plaintiffs Tom Girardi or anyone at Girardi Keese regarding, and I never participated in anything related to TXI cases. 6, I was completely unaware and did not participate in and did not provide any assistance of any nature regarding any conduct or scheme by anyone with the object or goal of harming plaintiffs or depriving plaintiffs of money that plaintiffs claimed was due to them. None of this evidence submitted by Ms. Girardi is relevant or dispositive. No one has ever claimed that Ms. Girardi knew plaintiffs or anything about TXI cases. They referred to Girardi Keese. That's not what determines whether she aided and abetted the misappropriation of funds by Girardi Keese. Of course, she did not know Phil Sheldon and Robert Finn because they were never invited to sail around the world on a yacht with Erica Girardi, Tom Girardi, and their friend Jim Wilkes, one of the referring attorneys who was an insider. So this is so shitty the way that they put this, because if she didn't have money, if she was just some other attorney's wife, that would not even be in there. Of course, she didn't know them, because he was never invited to sail around the world on a yacht with Erica and Tom. Shut the fuck up with that stuff. If I was a judge, that would piss me off, but that's my Justice boner going off. Plaintiffs were among the disposable attorneys, the suckers, to borrow Mr. Sheldon's term, who were lied to for years while Ms. Girardi spent their money to finance her fraudulent tax deductions on her personal return, as well as aid and abet the misappropriation of client funds by spending more money than Tom Girardi himself. She then allowed the firm to falsely carry her career expenses as $25 million bogus receivable that has never been paid back, and we are going on 14 years with still not one single payment from the EJ Global Receivable, a company solely owned by Ms. Girardi that was set up for herself and no one else. redacted Miss Girardi's new financier, and she's lying about that relationship too by suddenly claiming redacted to obstruct discovery, which makes no sense because redacted, and has been sending Miss Girardi substantial sums of money without consideration. If the relationship is redacted, as Miss Girardi claimed for the first time in response to plaintiff's opposition to her motion to keep the redacted bank records and redacted communications confidential, then redacted. A jury will consider the relationship and the efforts to keep the relationship secret, excuse me, which is further evidence that Miss Girardi is still lying about everything. Redacted. Miss Girardi knew her husband was constantly being sued by former clients and attorneys who were owed money, and she had personally been served with lawsuits that named her as defendant. Miss Girardi addressed in detail, redacted, contrary to the assertions in Miss Girardi's motion. Not knowing anything about the plaintiffs does not end the case against her, and a jury will decide if everything that she admits she knew about her own finances and her own company and her own tax records and everything else establishes knowledge of the misappropriation of funds that resulted in the serious harm suffered by plaintiffs. Throwing spaghetti at the wall to see what will stick. That's what it looks like to me, but I'm not an attorney. I think they see a fucking hot ass woman that is going to probably dig herself out of this, and that just pisses off those fucking dudes in suits. Miss Girardi is wrong about the law and ignores the many facts that will be considered by the jury to establish her liability at a trial. Miss Girardi's summary judgment motion fails in every possible way, and it's not even close. 2. Statement of facts. A. Erica Girardi receives tens of millions of dollars from Girardi Keese through her solely owned company, EJ Global LLC. Just making sure that we don't have any comments. Erica Girardi met Tom Girardi in the mid-1990s and they married January 7, 2000. Fact 8, Miss Girardi stated, immediately I started living Tom's life. It was a great legal education. I sat in on so many dinners and talks with bright legal minds. Fact 9, Miss Girardi understood that Girardi Keese was a law firm. Redacted. Listen, just because she sat in on many meetings and dinners and talks with bright legal minds doesn't make her an attorney. I have sat around bright legal minds. I am not an attorney. I deal with contracts every single day. I am not an attorney. Just because you sit in on something with people that are the thing you're sitting in on doesn't make you that. And I don't see how that can be argued in a court of law as, oh, she knows because, she hung out with attorneys. Get the fuck out of here. And generated income from contingency fee agreements. Although Ms. Girardi does not know plaintiffs personally, she understood that her husband worked with referring attorneys like plaintiffs. Redacted. In 2008, Ms. Girardi formed her solely owned company, EJ Global LLC, for the purpose of recording, distributing, and performing music under the name Erica Jane. 12. Ms. Girardi is LLC's sole member, 100% owner, and she signed her joint tax returns with Tom Girardi each year that contained a Schedule C for her LLC. Fact 13. Ms. Girardi testified that she recalls redacted. Fact 14. In 2018, Ms. Girardi wrote, the whole Erica Jane project was only possible because I'm self-funded. Now the haters are always going to say, all you do is spend your husband's money. First of all, it's our money. Know how I know? Because the IRS tells me that it is. My name is on the tax return too. But that's how they fucking get you when one of you does bad shit. Fact 15. On January 15, 2009, Ms. Girardi opened an account for EJ Global at Pacific Western Bank, and the second signer on the bank account was Norina Rouliard, an accountant at Girardi Keese. Fact 16. All of EJ Global's expenses were paid by Girardi Keese, which logged all expenses, including $14 million charged by Ms. Girardi on Girardi Keese American Express credit cards. Fact 17. Redacted. The expenditures included payments for Ms. Girardi's own personal assistants, producers, publicists, stylists, agents, managers, attorneys, travel, etc. Girardi Keese's 2018 taxes reflected an accruing $25 million receivable from EJ Global. Fact 18, Ms. Girardi testified, redacted. In 2017, the FTB audited EJ Global. Fact 20. Ms. Girardi was aware at issue was whether or not EJ Global LLC, EJG, is an activity engaged in for profit, or whether or not the expenses reported by EJG are ordinary and necessary business expenses deductible under Internal Revenue Code Section 162, to which California law conforms at Revenue and Taxation Code Section 17201. The FTB alleged EJ Global's income and expenses were consistent with a hobby and not a business, and sought assessments and penalties for tax years 2011 to 2013. Then they better go after fucking Donald Trump hard for what he did. So then it has Erica Girardi's formed EJG on July 28, 2008. Income and expenses for that date through 2014 were as follows. Total income in 2008 was nothing. And from 2009, it went from $10,448 to 2014 to $13,816. And then their expenses in 2008 were $331,297. And that resulted in a loss of $331,297,000. Then she went up over $1 million in 2009 in total expenses, resulting in loss. Losses of another $1 million, and increased all the way up to 2014, where she ended up with a loss of $3,630,000. And that seems logical to me, because if you're trying to self-promote yourself in a music industry, it's not cheap, you know? I mean, I know self-publishers, they got to pay for their own books and shit. So I'm just going off of that. Not my opinion. I don't know. Could be wrong, whatever. IDXK, the tax returns reflect that every year millions were spent without any meaningful income being generated. Yep. And redacted. In sum, for years, Ms. Girardi knew that a law firm, Girardi Keese, was financing her music hobby, which cost millions each year, generated no income, and was under investigation for tax evasion. She knew her lifestyle was being funded by Girardi Keese, even though she is not an attorney and has never worked at Girardi Keese, which is a law firm and not a record label. No music career in the history of music has ever been launched in this manner, and it only happened here because it allowed the Girardis to make massive deductions on their personal returns as a tax fraud. Ms. Girardi's celebrity also helped her and her husband falsely project an image of wealth and success that helped to lure unsuspecting victims like plaintiffs and the clients who entrusted their claims and settlement funds to her husband and his firm. Well, and because she's on the Real Housewives, and they're hoping they can get on there too, or they can get their broads on there, or whatever the fuck they're doing. Because a lot of people have made a lot of money from coming on these shows, promoting their own brands and whatever the heck they're doing. So, you know, everybody's looking for their own self and how they can make some money. And everybody always thinks they're smarter than everybody else. B, with Erica Girardi's substantial assistance, Tom Girardi and David Lira steals settlement funds from clients and co-counsel, including plaintiffs. Plaintiffs and Girardi Keese jointly represented clients in personal jury cases referred to as the TXI cases, and agreed to equally share the attorney's fees. Fact 22, Girardi Keese prepared the retainer agreements, which advised the clients of the 40% contingency fee to be shared among co-counsel, and further advised that the association of co-counsel will not affect the total attorney fees charged to client. Plaintiff performed significant work over a period of many years in collection with the TXI cases, and Mr. Girardi and Mr. Lira never disputed plaintiffs were owed their fees. Fact 24. The TXI cases were resolved with a cash settlement. Fact 25. After settling the cases, Girardi Keese sent to each client a consent form to be signed, settling forth the amount of the recovery for each client's case and the percentage of the client's recovery owed for attorney's fees. Fact 26. On January 16, 2015, the defendants in the TXI cases wired an initial settlement payment of $20 million to the Girardi Keese Torrey Pines Bank client trust account. Fact 27. Over the next few months, Mr. Lira signed hundreds of checks to Girardi Keese operating account and to pay off older debts of the firm. By the time Girardi Keese made its first payment to any TXI client on August 2015, the client trust account had a balance of $4.4 million. By the end of October 2015, the client trust account had only $411,000 in it, and Girardi Keese had only paid 256 of the 2,200 TXI clients, a total of $2.3 million, and had not paid any co-counsel their share of the attorney's fees. Well, those guys are jackasses. The bank statements confirm that in 2015, Girardi Keese took and spent its share of the attorney's fees and also took and spent plaintiffs' and other referring attorneys' shares of the attorney's fees, and also took and spent most of the settlement fees funds that belonged to the TXI client. Unknown to plaintiffs at the time, Girardi Keese's ability to pay them and the clients depended entirely on Girardi Keese's ability to settle other cases on behalf of other clients. Yep, that was some kind of a Ponzi scheme they had going on there. New settlements occasionally flowed into the client trust, but it was not substantial because of the tens of millions of dollars of Girardi Keese funds that were being siphoned off and expended to finance Ms. Girardi's lavish lifestyle. The Girardis lied to everyone. Girardi Keese borrowed millions from lenders and pledged as collateral the attorney's fees from the TXI cases that had already been spent and the profits from Ms. Girardi's music hobby that was financed by the same law firm that needed the loans because of its expenditures on Ms. Girardi's music hobby that the Girardis knew generated no meaningful income. Fact 28. See, I can't explain that, and that's kind of sucky, and that's the part Erica really needs to start addressing, but I'm sure she can't because her attorney's probably telling her to keep her mouth shut. On September 17th, 2019, Ms. Girardi signed an agreement that stated, "I am married to Thomas V. Girardi. We have been together for 20 years. I agree that California Attorney Lending II, Inc. has a first lien on any assets owned by Thomas V. Girardi and any assets which are community property." Fact 29. Prior to signing this agreement, Ms. Girardi was aware of multiple lawsuits against her and her husband alleging that Girardi Keese had failed to pay back two $5 million loans. Fact 30. Ms. Girardi knew the financial situation at Girardi Keese was so dire that the firm could not borrow money unless she agreed to pledge her own personal assets. Girardi Keese repeatedly told plaintiffs that TXI settlement funds they had already stolen could not be dispersed to anyone until issues involving a class action administrator, KCC, were first resolved, and then told KCC that they couldn't pay them until disputes with co-counsel were first resolved. Fact 31. Also known to plaintiffs, Mr. Lira and Mr. Girardi began receiving irate calls and emails from the survivors of victims of the Lion Air plane crash in Indonesia who were asking for their money after settlements were paid by Boeing and Girardi Keese. Fact 32. Meanwhile, for years, Ms. Girardi played her part by using her public platform to obfuscate the scheme for the purpose of keeping Girardi Keese creditors at bay and the firm's money flowing to her. When asked by the media years before the collapse whether lawsuits accusing her husband and his firm of misappropriating funds would impact her notorious spending habits, such as her $40,000 per month glam squad, Ms. Girardi falsely claimed that she pays her own bills even though she knew her lifestyle was funded by Girardi Keese, that it was improper and needed to be hidden. Fact 33. What this says to me is that we need to overhaul our legal system. So why couldn't Boeing have just paid the settlement out and just be monitored by attorneys instead of, why should the money go into an attorney's account and then the attorney gets to pay them out after they pay their bills? That seems like a recipe for disaster to me. Why not give the attorneys their money, give the plaintiffs their money, and have it looked at by the court saying this is how this is going to be? You see what I'm saying? I just don't understand why we let this kind of shit go down, because when you're messing with lots of money and you got a lifestyle you want to keep, funding, people are going to do stupid shit. When asked about lawsuits against her personally that specifically alleged that Girardi Keese transferred money to her, Ms. Girardi said, "Listen, we're in the lawsuit business, baby. We sue and get sued." Fact 34. Ms. Girardi also falsely stated that the legal issues were resolved and they apologized. However, Ms. Girardi knew that the lawsuits were not resolved with an apology from the plaintiffs, but rather was resolved by Tom signing a stipulated judgment for $6 million. Redacted. Fact 35. These false statements and others were made to help keep the hordes of Girardi Keese creditors at bay, and whom Ms. Girardi helped lull into believing that her husband and his firm could and would satisfy their obligations and were being truthful at all times. Well, he's an attorney. They're not being truthful at all times. They're paid to lie. On December 9th, 2020, the instant action was filed. A few days later, the scheme fully imploded when the United States District Court for the Northern District of Illinois ordered Girardi Keese to show up for being in contempt of the district court's order regarding distribution of the Lion Air settlement funds. Fact 36. And this was just tossed out of court without what is it called? Without prejudice. So they can bring it to court, and they are going to in California. So this one was just resolved, at least in Illinois. The district court ordered Ms. Girardi and Mr. Lira to appear, and after a hearing on December 14th, ordered Girardi Keese assets frozen and referred the matter to the U.S. Attorney's Office. Shortly thereafter, Tom Girardi and Girardi Keese were forced into involuntary bankruptcy. After the December 14th, 2020 hearing, see, look at how slow it goes, too. That's the thing I'm saying. So this court hearing that happened in Illinois was just tossed out, well, during filming of The Real Housewives, because that was already filmed and done. But whenever that was filmed in 2022, I'm guessing, or late 2021, this shit was just now being settled. It takes forever, and this is not even the divorce. Mr. Lira removed the instant action to the bankruptcy court. However, plaintiffs dismissed Mr. Girardi and Girardi Keese and their contract and fraudulent transfer claims, and the case was remanded to this court to adjudicate the tort claims against the remaining defendants. See, Erica Girardi receives funds from, and then that's all redacted. And I don't have any questions or comments yet. Okay. But counsel's assertions are meaningless. Ms. Girardi then filed a motion to maintain the confidentiality of the Wells Fargo bank records and the information contained in them. Redacted. It's a complete sham. If the jury finds she lied about redacted, the source of the money, they can disregard the other testimony of hers. D. Erica Girardi's ongoing efforts to obfuscate the truth. On November 3rd, 2020, 1 month before the scheme fully imploded, Ms. Girardi filed for divorce. Fact 43. California Family Code Section 910 provides that the community estate is liable for a debt incurred by either spouse before or during marriage, but does not include the period after the date of separation. When Ms. Girardi was accused of filing a sham divorce to protect her assets from creditors, she sought to establish reason for the divorce unrelated to the imminent collapse of the scheme from which she benefited more than any other person, but claims to have no knowledge of at the time she filed for divorce. On December 18th, 2020, People.com reported that a source close to the couple told People that the reason Ms. Girardi filed for divorce was because she believed Tom Girardi had been unfaithful. Fact 44. Then, because there was no evidence of Tom Girardi, who was allegedly mentally diminished, having an affair in 2020, Ms. Girardi attempted to confirm the accuracy of the People.com article by publicly posting that same day on Instagram text messages between Mr. Girardi and Honorable Patricia Ann Bigelow, retired, who at the time had of the alleged affair was the president presiding justice of the California Court of Appeals, 2nd District. But Ms. Girardi's plan backfired when it was quickly determined that the affair had happened many years earlier, and it became obvious to everyone that the text Ms. Girardi had posted had been clearly saved for years until an opportune moment when Ms. Girardi determined they would be most useful. Ms. Girardi's efforts to turn the spotlight on someone else and rebut the sham divorce charge only created more evidence that Ms. Girardi is not being truthful. I don't know shit about that. Ms. Girardi then changed course and sought to use her public platform to advance the narrative that she divorced Tom Girardi because of his mental decline, rather than to protect her assets. But in doing so, Ms. Girardi made statements on The Real Housewives show that her castmates and viewers quickly identified as inconsistent with her prior statements on the show. In an episode of Real Housewives filmed in 2021, Ms. Girardi talked about an alleged single-vehicle car accident in 2017 in which Tom Girardi was involved. She stated that Mr. Girardi drove his car off a cliff and that Ms. Girardi found him after he was unconscious for 12 hours, and Tom had suffered a head injury, broke his shoulder, snapped his ankle, and then broke his clavicle. Fact 45. She claimed that Mr. Girardi's personality completely changed after the crash. She said 3 years ago he had a terrible, terrible head injury, and there was a significant shift in his personality, his decision-making, and who he is. Ms. Girardi further explained that part of brain trauma is making bad decisions you wouldn't normally make. However, castmates and viewers noted that when she talked about the alleged accident in 2017, Ms. Girardi only referenced an ankle injury and said it was fine and it could have been much worse. Ms. Girardi then confirmed this version of the story several more times in multiple interviews where she said Tom is perfectly healed, he's great, he's good. Tom is a little superhuman in a way. He healed and he's back at it, so there you go. 2 months later, in March of 2018, when asked about Tom's injury, Ms. Girardi nonchalantly replied, he broke his ankle, he's fine, he's had 3 pins. He healed up so well, he broke his pins, so he's good. Either Ms. Girardi was lying then to lend further aid and support to the scheme and the misappropriation of funds that financed her lifestyle by attempting to maintain confidence in her husband and his firm, or she's lying now about Tom's brain injury in an attempt to justify the sham divorce she filed 1 month before the scheme imploded and to continue to aid and abet the scheme. If it appears she's lying now, just weeks after the alleged accident, Ms. Girardi and Tom filmed a scene in their kitchen for season 8, episode 9 of the Real Housewives. Though his shoulder and clavicle were allegedly broken at the time, Tom was not wearing any cast slings or harnesses of any kind and appeared to be moving his arm and shoulders normally. Fact 46. Further, another investigation concluded that the Pasadena police have no record of Tom's accident taking place and have no evidence whatsoever of the crash. Ms. Girardi has made other statements in an effort to aid and abet the scheme. On the May 18, 2022 episode of Watch What Happens Live with Andy Cohen, Ms. Girardi was asked by Andy Cohen, was there ever a time during Tom's run that you thought things aren't adding up or this is weird? Ms. Girardi answered, no. Look, you had the sitting governor of California, Gavin Newsom, on the show talking about him. So if the governor doesn't, quote, know, how the fuck am I going to know? When asked at her deposition, redacted. On the same episode, Andy Cohen asked Ms. Girardi about public statements made by Bethany Frankel, a former cast member of The Real Housewives of New York, who said that she was told in 2018 that Tom Girardi was using other people's money to support Ms. Girardi's lifestyle and that it was widely known. Fact 48. Ms. Frankel stated that her former boyfriend, who passed away in 2018 at age 51, had told her this. Ms. Girardi responded, in the business that Tom was doing, which was contingent fee, it is not unusual to borrow. So while that may be true, there were also loans that were paid off. However, Ms. Frankel's statements were not specific to the issue of unpaid loans, and Ms. Girardi did not address the broader misappropriation allegations. Instead, Ms. Girardi deflected and said, so I don't know where Bethany's coming from, and her guy's dead and my guy's in a home. So whatever. But at the same time, that's kind of the way the business goes. On an episode of Real Housewives that aired in June of 2022, Ms. Girardi stated, "We're not even sure that there were people that weren't paid." And when asked if there was a chance that the victims can be lying, she said there was, even though Ms. Girardi knew that people, in fact, were not paid, and victims like the Lion Air clients and plaintiffs were not lying. On May 20th, 2021, Ms. Girardi posted on Instagram drawing for herself on a cross under which she wrote, why would she do that? Scapegoat. But, when you're going through a divorce, you do crazy shit. I'm just going to tell you, like really crazy shit. Like eat yourself into a food coma, need therapy and not get it, pull your hair out in your car while you're driving. You lose your shit. It's not an easy thing. And now this is out there for the whole world to see all their mess. Mine was my own that nobody saw, Oh, just kills me. In the drawing, Ms. Girardi depicted wearing earrings that say orphans and widows, a reference to the orphans and widows of the victims of the Lion airplane crash. And the earrings were a reference to a set of earrings valued at $1.5 million that were purchased by Ms. Girardi with Girardi Keese funds. That's not a good look, Erica. Ms. Girardi fought the bankruptcy trustees in court to keep the earrings, but lost. The earrings are now the trustees. Three, discussion. A, Rule 2-200 has no application to this tort action. Ms. Girardi's lead argument is that the retainer agreements prepared by Girardi Keese purportedly did not comply with CRPC 2200, because even though the retainers identified plaintiffs and Girardi Keese as co-counsel and advised each Finn Girardi client that in the event of a recovery, the 40% contingency fee would be paid to Girardi Keese and law offices of Robert P. Finn, hereafter attorneys, and advised each Sheldon Girardi client the 40% fee would be paid to Girardi Keese law offices of Philip Sheldon, hereafter called attorneys. The agreements did not say the firms would share the fees equally. Facts 1, 2, and 23. According to Ms. Girardi, this means the case against her must be dismissed as a technicality rather than the merits of the trial, but she is wrong about the law. Well, which is it? Does she know about the law because she hung out and had dinners with these people, or is she wrong about the law and misinterpreted it? I think like your argument is back and forth here, dudes. The court correctly rejected the same argument when it overruled Mr. Girardi's demurrer, and it should reject the argument again because plaintiffs are suing in tort, not contract, and they are not pursuing claims against Tom Girardi or Girardi Keese. That's why the bankruptcy court remanded the case. Also, plaintiffs are not trying to recover the TXI settlement funds because that money is long gone. Plaintiffs are suing Ms. Girardi for her own tortious conduct. Ms. Girardi's authority, Chambers versus K, 2002, 29 Cal 4th, 142, is distinguishable because that was a contract action and not a tort action against individuals like Ms. Girardi, who is not a party to the retainer agreements. Ms. Girardi does not even have standing to challenge the validity of the retainer agreements prepared by Girardi Keese. Regardless, Ms. Girardi is wrong that noncompliance with Rule 2-200 forecloses recovery by plaintiffs in this action. And Huskinson and Brown versus Wolf, 2004, 32 Cal 4th, 453, 463, the California Supreme Court expressly held, although we approved Rule 2-200, attorneys did not act in violation of an express statutory prohibition when providing legal services pursuant to a fee-sharing agreement lacking written consent, where services are rendered under a contractual compensation agreement that is unenforceable against public policy. But the subject services are not otherwise prohibited, quantum merit may be allowable. Huskinson and Brown versus Wolf, 2004, 32 Cal 4th, 453, 463. See also Cohen versus Brown, 2009, 173 Cal App 4th, 302, 319-20. Citing Huskinson's 31 Cal 4th at 460, an attorney who labors under an unforeseeable agreement nonetheless deserves reasonable compensation for his or her services. To me, like I said, I think they're just trying to find some money for these people that got fucked by Tom. And so they're just going to go after her because they're going to take her shit that they can, $25 million worth of shit that they can sell of hers, if there's $25 million worth of shit that they can sell. If I was Erica, I would sell it and give it to them just to try to keep my ass out of hot water. Not because I think she's guilty of anything. Plaintiffs are not seeking to recover quantum merit in this tort action, but if recovery in quantum merit from the parties to an alleged unenforceable agreement is allowable, then separate and distinct tort claims against non-parties to the agreement are certainly allowed. The right to pursue a claim for aiding, abetting, breach of fiduciary when a contract claim is foreclosed was recognized in American Master Lease LLC versus Idanta Partners Limited. In that case, plaintiff corporation invested in real estate and alleged that the defendant venture capital firm aided and abetted a breach of fiduciary duty by the managers of the plaintiff's corporation when they formed a separate corporation with the defendant to operate a real estate investment business. The defendant there argued that the plaintiff's claims for interference and contract and aiding and abetting breach of fiduciary duty were barred by the statute of limitations, and on that basis that there has not been proof offered of a valid and enforceable contract. While the 2-year statute of limitations barred plaintiff's interference with the contract claim, the Court of Appeal held that the aiding and abetting breach of fiduciary duty claim was controlled by the statute of limitations for breach of fiduciary duty, which is 3 or 4 years, depending on whether the breach is fraudulent. The Court of Appeals rejected defendants' arguments that the two-year statute applied since a contract agreement created the underlying fiduciary obligations, and held the fiduciary duties were not created exclusively or even primarily by the operating agreement, but were imposed by law on them as members and managers of AML. Huang Kuo, Inc. versus Liu, 2007, 150 Cal. Okay. The duty of loyalty arises not from a contract, but from a relationship. Although an express agreement between the parties may govern their relationship, to the extent that their respective rights and duties are not spelled out in the express agreement, the law imposes obligations arising out of the nature of their fiduciary relationship. Corp versus McSweeney, a cause of action for breach of fiduciary duty is on its own right sued on. Plaintiffs tort against Ms. Girardi and their own rights sued on. Ms. Girardi's liability arises from her actions to aid and abet a years-long scheme that unjustly enriched her to the detriment of others, including plaintiffs. Ms. Girardi's Rule 200 argument fails because the rule has no application to this tort action, and the court can and should reject Ms. Girardi's argument on that basis alone. But even if this was a contract action, the argument would still fail because the Supreme Court confirmed in Huskinson that the contract that does not comply with Rule 2-200 is not an illegal contract, as Ms. Girardi argues. And since it does not have an illegal object, it is not one which neither party may enforce. Yuba Cypress House Partners Limited versus Area, this is the case law they're citing. Even if the contract was illegal, attorney's fees could be awarded under an illegal contract to a party who was innocent of creating the illegality. See also Mountain Air Enterprises LLC versus Sundowner Towners. Reviewer granted on unrelated ground in opinion superseded sub nom, holding where parties did not share in drafting the agreement. They are not in pari delicto, and the innocent party can recover attorney fees under this agreement. Defendants' reliance on Black Hills and 6Ls, like their reliance on Yuba Cypress, is misplaced. Like Yuba Cypress, both cases involve parties to an illegal contract that were not in pari delicto. Black Hills Supra Defendant, the apparent author of the illegal contract, Six Cells Supra. Plaintiff, the author of the illegal contract. See also Ubra Cyprus. Although plaintiffs chose to void the contract, this does not preclude him from recovering attorney fees via the money fees clause in the contract. Rather, defendant who violated the Subdivided Lands Act is stopped from asserting the invalidity of the contract. Otherwise, the court would have assisted defendant in profiting from its own wrong. To deny plaintiff the attorney fees to which he is entitled as a result from the contract would permit defendant to benefit from the illegality that it created. The same principles of equity should be applied here. It is undisputed that Girardi Keys drafted the retainer agreements that Ms. Girardi now claims are unenforceable. Girardi Keys could have advised the clients at any time that the fees would be split equally, including after the TXI case settled, when Girardi Keys sent the clients consent forms to be signed. But they failed to do that. Girardi Keys, Tom Girardi, and David Lira never once raised the issues with plaintiffs and never took the position that the fees would not be paid due to Girardi Keys' allegedly defective retainer agreement. If this was a contract action, Girardi Keys would not only be stopped from relying on Rule 2-200 because it was responsible for causing the alleged defects, but Girardi Keys and Ms. Girardi also have unclean hands and received all the benefits under the agreements Ms. Girardi now claims are defective. Girardi Keys and Ms. Girardi are equitably stopped from asserting a contract defense based on Rule 2-200, which in any event has absolutely no relevance to this tort action. Finally, if this were a contract action to which Rule 2-200 applied, plaintiffs could still cure the alleged defect even after the services have been performed. Cohen versus Brown, 2009. We also note that 2-200 requires only that the client's consent to a division of fees be given prior to the actual division of fees. It does not require client's consent to the commencement of work by the associated in-attorney law firm. Thus, in this case, it is still possible to fulfill the requirement of Rule 2-200. However, there is no reason to require plaintiffs to contact the 1,800 joint clients to obtain consent for the co-counsel to divide equally the attorney's fees they were already told would be divided because Girardi Keys caused the funds to be dispersed to Girardi Keys and others in 2015. And this case is about Ms. Girardi's and Mr. Lira's own tortious conduct because the other dude is fucking in the nut house. B, the motion should be denied because Ms. Girardi has failed to satisfy her burden on the motion and there are tribal issues of fact. A defendant is liable for aiding and abetting another in the commission of an intentional tort, including a breach of fiduciary duty, if the defendant knows the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other to act. But no, how does she know? I still don't believe she knew anything. Nazrari versus Buck Consultants. A defendant may be found liable for aiding and abetting a breach of fiduciary duty, even though the defendant owes no independent duty to the plaintiff. Ms. Girardi argues that she could not have aided and abetted a breach of fiduciary duty because, according to Ms. Girardi, Tom Girardi and Girardi Keys owed no fiduciary duties to plaintiffs. Motions P13 and 21 through 27. Ms. Girardi's argument is based on the holding in Beck versus Wecht, 2002, another authority that has no application in this case. In Beck, the question was whether one co-counsel may sue another for breach of fiduciary duty on the theory that the later's malpractice in handling their mutual client's case reduced or eliminated the fees the former expected to realize from the case. Unlike the plaintiff in Beck, plaintiffs here do not allege that Tom Girardi or Girardi Keys mishandled the TXI cases and thereby reduced or eliminated the fees. The TXI cases were settled cases, and the fees were paid to Girardi Keys, which had a fiduciary duty to disperse amounts owed to plaintiffs Girardi Keys, instead misappropriated the funds. This action involves the handling of the funds received by Girardi Keys after the TXI cases were resolved. So Beck is not even remotely on point. The argument is so frivolous, it's not even funny. The State Bar Trust Account Handbook specifically cites numerous cases involving duties to third parties. See example in the matter of Kaplan and State Bar Court Reporter 547, where client asked the attorney to distribute trust account funds claimed by both the client and the third party to whom the attorney owes a fiduciary duty. The attorney must promptly take affirmative steps to resolve the competing claims in order to disperse the funds. Guzetta versus State Bar. Holding an attorney's fiduciary obligation to account and pay funds extends to both parties claiming interest therein, and a duty extends to opposing party's spouse. Ooh, Simmons versus State Bar. When an attorney receives client money on behalf of a third party, he has a fiduciary duty to help, duty to the third party. Girardi Keese had a fiduciary duty to plaintiffs to disperse and not misappropriate the money plaintiffs were owed, and any contention otherwise is both legally and factually wrong. Ms. Girardi argues that based on the undisputable facts, there's no evidence to support an aiding and abetting claim. Motion page 14, INS 13 through 15. However, Ms. Girardi's alleged undisputed facts are, for the most part, not material or relevant to the aiding and abetting claim against her. In her opposition, Ms. Girardi references the following alleged undisputed facts. Ms. Girardi has no knowledge of the TXI cases or the dealings and transactions between plaintiffs Tom Girardi and Girardi Keese recording those cases. Ms. Girardi has no knowledge of, never communicated with plaintiffs Tom Girardi or anyone at Girardi Keese about, and never participated in, A, any of plaintiffs' purported agreements or transactions with Girardi Keese or Tom Girardi related to the TXI cases. B, plaintiffs' requests for payment of sharing or fees splits related to the TXI cases. C, the receipt by Girardi Keese of any funds related to the TXI cases. Or D, Girardi Keese and or Tom Girardi's disbursement of funds relating to the TXI cases. Motion page 16, 14 through 22, emphasis added. Ms. Girardi's declaration could not be more narrowly written. In her effort to avoid committing to any statements that could subject her to the penalties of perjury, Ms. Girardi submitted evidence, in quotations, that does not even come close to satisfying her burden of proof on the motion, because it is irrelevant whether or not she's heard of the TXI case specifically, or has ever met or heard of Philip Sheldon or Robert Finn. Plaintiffs only need to establish a trial that Ms. Girardi had actual knowledge of the primary violation, and knowledge can be inferred. And they cite Casey versus U.S. Bank National Association. In this case, the primary violation, like in Casey, is the misappropriation or evidence of funds from Girardi Keese. Essentially, the trustee alleges the banks aided and abetted certain officers and directors of DFJ, the DFJ fiduciaries, in their scheme to unlawfully divert more than $36 million in investor funds from the corporation. Here, too, plaintiffs allege that Ms. Girardi aided and abetted her husband in his scheme to unlawfully misappropriate or divert funds that Girardi Keese had a fiduciary duty to pay to others. Citing in Re Sharp Intern Corp. As the court explained in Sharp, the relevant injury then is whether the trustee adequately alleges the banks had knowledge the DFJ fiduciaries were misappropriating funds from the DFJ. In Casey, the court concluded that trustees had failed to allege facts showing that the banks knew the fiduciaries were misappropriating corporate funds. Thus, the trustees failed to state a case of action for aiding and abetting a breach of fiduciary duty. Am Master Lease LLC versus Idonta Partners Limited, 2014. On the other hand, it is equally clear that if the trustee can allege the banks knew that DFJ fiduciaries were stealing corporate funds and knowingly assisted the DFJ fiduciaries in laundering the stolen money, those allegations would suffice to state a claim for aiding and abetting the theft or breach of fiduciary duty. Casey 127. Here, there is substantial evidence that would allow a jury to conclude that Ms. Girardi knew she was the beneficiary of misappropriated funds, and she also cannot avoid liability by being willfully blind to the misconduct around her, because it was well established under California law that the willful blindness is to be regarded as equivalent to actual knowledge. Levy versus Irvine. Failing to investigate when put upon inquiry, he is chargeable with all the knowledge which is reasonable to suppose he would have acquired if he had performed his duty. See also matter of Carver in 2016. Carver is culpable of moral turpitude by committing the unauthorized practice of law through willful blindness, which is tantamount to having actual knowledge that he was ineligible to practice law. Bank of America National Trust and Savings Association versus Greenbach. It is, of course, the law that a party has a duty to investigate where he has notice of facts which indicate fraud. Buena Vista Oil Company versus Park Bank of Los Angeles, 1919. The very name of the payee casts the shadow upon the check, which could have been removed by the performance of the bank of its plain duty under the law, that of inquiry. But banks have a fiduciary responsibility. Do individuals who are not a party to the companies that their spouses work at have a fiduciary responsibility? This is why they're trying to ram her butt into court. Rawell, 1889. Man, he's reaching. The defendant cannot be allowed to shut his eyes and say he did not see when by opening them he might have seen. Ms. Girardi signed all of the documents relating to her business affairs, which facilitated the receipt of most of the misappropriated funds. One who assents to a contract is bound by its provisions and cannot complain unfamiliarity with the language of the instrument. Madden versus Kaiser Foundation Hospital, 1976. Ms. Girardi cannot receive the benefit of the agreements she signed by spending millions of dollars of misappropriated funds and then disavow the signed documents after she puts faith in representations, which are shown by facts with her observation to be so patently and obviously false that she must have closed her eyes to avoid discovery of the truth. Beckwith versus Dahl, 2012. She also cannot disavow her agent Tom Girardi's handling of her own business affairs. Either EJ Global is Tom's company and Ms. Girardi has repeatedly lied under oath, or Tom Girardi is Erica Girardi's agent, which creates its own liability by allowing her LLC to be used by her agent to facilitate the theft. Ms. Girardi will not be able to credibly claim at a trial that she believed her husband was just a really successful lawyer who made a lot of money, and she had no idea over the course of her 20-year marriage Tom Girardi and Girardi Keese were engaged in any wrongdoing, and there was never any reason for her to make any further inquiries. The evidence submitted in support of this opposition establishes that Mr. Girardi was inextricably intertwined with Tom Girardi's and Girardi Keese's business affairs, and a jury will have to decide whether the things she saw and did established aiding and abetting liability. The jury will decide if her signing of all the tax returns, spending over $25 million of firm's funds, and engaging in tax fraud on her personal return is knowledge or not. There are clearly triable issues of fact on multiple levels here. Plaintiffs do not dispute that Ms. Girardi is not and never was an attorney. Good, because I was wondering about that. UMF number 3, and that during her marriage to Tom Girardi, Ms. Girardi had a separate career as an entertainer and never worked at Girardi Keese, UMF number 4. But those undisputed facts establish that summary judgment cannot be granted because it is not normal for a non-lawyer with a specific career to run all her finances through a 30-year law firm where she has never worked, and it is not normal to charge $14 million to the firm's credit cards and have the firm spend $25 million on an entertainment career that is generating virtually no income. The Franchise Tax Board told Ms. Girardi there were serious legal issues with how she and her husband were entangling their respective businesses together. Yeah, that was pretty bad. She had her own lawyer and access to other lawyers and accountants, but made no inquiries. Under Family Code Section 721, the financial transactions between Erica and Tom Girardi created a fiduciary relationship subject to the same rights and duties of non-marital business partners that provided Ms. Girardi with access at all times to any books kept regarding transactions for the purpose of inspection and copying. I don't know. True and full information of all of the things all things affecting any transaction that concerns the community property and accounting. That might be true, but that doesn't mean she actually could get her hands on those things. And that's the thing, you know? Ms. Girardi claimed that she lacked true and full information about the staggering sums of money she was receiving, even more specious given her statutory right to access the information, and provides additional grounds for the jury to conclude that Ms. Girardi had actual knowledge of the primary wrong. A jury should have the opportunity to consider many lawsuits filed against Tom Girardi, Girardi Keese, and Ms. Girardi personally, and personally served on her, alleging the misappropriation of funds and the failure to pay back loans. A jury should consider her public statements when asked about the lawsuits, and if they are consistent with the statements of an innocent spouse who claims to know nothing about her husband's business affairs. A jury should consider whether it makes sense that Bethany Frankel, a cast member of The Real Housewives of New York, who said her boyfriend at the time told her about Tom Girardi's misappropriation of funds back in 2018, would know more than someone who lived with Tom Girardi for 20 years and was the person who, in fact, spent most of the stolen funds. A jury should consider Ms. Girardi's efforts to prove her divorce was not a sham by attempting to draw attention to Tom Girardi's alleged affair with a judge, and the conflicting stories about Tom Girardi's car crash when she then came up with a different reason for why she filed for divorce 1 month before the scheme imploded. The jury should also have the opportunity to consider that Ms. Girardi, redacted, is a critical piece of evidence the jury can analyze. The court can instruct the jury accordingly. This is an overwhelming amount of evidence for the jury to consider, and Ms. Girardi cannot end the case against her by submitting a carefully written declaration confirming obvious facts and then just saying over and over that she didn't know anything was amiss and that she just blindly signed what she was told to sign to allow the money to flow to her, and said that she was told what to say to make sure it continued to flow to her, and then spent all the money and didn't ask any questions. Ms. Girardi will have an opportunity to tell her story to a jury, and plaintiffs are entitled to tell the jury why her version of events is not believable or is not a valid defense. But this is not a case where summary judgment is in any way appropriate or applicable. And this was on August 15th of 2022. So if you stuck around for all of this and you feel differently than I do, I don't think she should be held responsible. I think that she didn't know. I think that he ran that house. Tom Girardi ran that house like with an iron fist because it was his fucking money. And he might have given her some. And she maybe, I don't know, might have thought he's an attorney. He's got to be doing some crazy shit over there. But I don't think she concerned herself too much with what he was doing. And I still think that those other bitches that are giving her so much shit about her going through this divorce and the way she's acting and what she's drinking and what she says and how she flies off the handle are not even taking into consideration what it would be like if all of a sudden their lifestyle was completely pulled out from underneath them. So anyway, what do you think? please let me know in the comments, and I will put a link to this that I read out there so that you can see it. Have a good day.